Welcome, everybody. Let's take a look and let's go without the slides to begin with, and then we'll get into the slides. All right. Hello, everybody. This is Howard Klein. And in this webinar, which I've entitled Business Liability in a Coronavirus World, in this webinar, I will be discussing the potential, keep in mind, potential civil and criminal liability that businesses may be exposed to as they reopen for business during this COVID-19 pandemic. And I say during because I believe that it's not over. We've got, in my opinion, a ways to go. For record-keeping purposes, the date of this webinar originally was aired on June 18th, 2020. In addition to discussing the potential liability, I will also be discussing ways to avoid or help you avoid or minimize the risks of liability, as well as the practical considerations. In reality, is this liability something that you should really worry about? Should you take action? And that liability goes to the issue of being able to prove that you're liable, the practical considerations, as well as a practical consideration of whether or not, or whether or not attorneys are going to handle these lawsuits. And that is a practical consideration, I might add, brought on by my friend, Jeff Millman, who I refer personal injury cases to. And he raised this issue in a conversation with me, and I agree with him. I think it's a point well taken. This webinar is for any businesses that have employees or comes in contact with the public. I am not providing legal advice in this webinar. My intent is to educate and inform. With that being said, I encourage you to contact me for assistance. As such, this may be considered attorney advertising. Now, let me tell you what my perspective is on this and where I'm coming from, just so that you know what my bias is. I've been an attorney who, on many occasions, has advised clients on how to avoid liability. That's been my job, on and off for many, many years. I am conservative by nature. I think of all the possibilities that could go wrong, and then I think of how to avoid those possibilities. That's generally been my job, particularly when I've been in-house. Understand that in order for a business to run properly, there's a balance. I've often told people, if all you ever did was listen to me and no one else, then you're not going to make money. So in the positions that I've been in, particularly those are in-house, the business people and I have had to balance that, how much should we act or react? And can we make money paying attention to what Howard's telling me? So that's an important consideration. And you need to know that that's the perspective that I come from, which is generally worrying about things. That's my job. Just so that you know, if there's any doubt in your mind that lawsuits are going to be filed as a result of the COVID-19 and all kinds of lawsuits, I have read that there has already been, by the end of May, 404 class action lawsuits. And understand, these are big lawsuits. These are the bigger ones, generally speaking. And I'll get a little bit more into that near the end of the webinar. Okay. For those of people, and since I'm recording this, so if anybody's watching the recording and either on YouTube or on Facebook, Please subscribe to my channel. That's creradio.com channel, and click the little bell, which means that you would get all of my videos that I put on there. And follow me on Facebook. Follow CRE Radio on Facebook. I'm going to be talking about civil and criminal liability. And I don't want to scare anybody, but there's that potential out there, and I think it's real. I really do. I've been an attorney for now going on 44 years. I have primarily focused in commercial landlord-tenant matters, lease negotiations, and disputes. I've also been a former general counsel for Big Bear Markets, as well as 3 other corporations, so I am very familiar with personal injury and premises liability cases. I'm also currently offering services as an arbitrator and mediator exclusively in commercial landlord-tenant disputes. Okay, we're going to start with civil liability because this is where I believe most of the liability will lie. There are, on occasion, may be criminal liability, and I will explain why that is somewhat limited. All right, and then we'll go in. So in terms of civil liability, basically in this webinar, I'm talking about some form of negligence, the plain vanilla negligence, and then there's a higher culpability of gross negligence, recklessness, and willful misconduct. There's also the tort, an intentional tort, such as where someone might have COVID, they know about it, and they purposely spit on someone with the intent to causing those people harm. That's not really what we're talking about during this webinar. We're talking about the various forms of negligence. So why don't we move on with that? So let's talk about some of the essential elements of negligence. Damages being one, but I'm not really going to be talking about that if there are any attorneys out there. So the first question is there a duty owed and to whom? So in this particular case, if we're talking about a business where the public or employees are on premises, I think it's fair to say that a business will have liability to protect if they fail to protect their employees and the public. I don't think the duty owed is much of an issue. I think we had a question before the webinar started with someone who actually visits other people and they want to know if they potentially could have liability. The answer is yes, even then. If you know or should know that you can spread the disease to someone else, it's that person. So if you go see business clients, you really owe a duty to them. One of the key issues here is going to be the reasonableness of the conduct. And this is not a black and white issue, except in instances in which there's a statute or some regulation that clearly defines what your duty is and how reasonable your conduct should be. All right. But in many instances, this reasonableness standard is going to vary from region to region, city to city, country to country, and will vary depending upon the conduct itself. Another issue is the burden of proof, which we'll get into in more detail. But obviously, if there's criminal conduct, the burden of proof is much steeper than it is in a civil context. So let's talk about actual negligence. The burden of proof in actual negligence is by a preponderance of evidence. That means it just needs to be an itty-bitty fraction more than 50%. That's the burden that a plaintiff or an aggrieved person must prove in order to get a judgment for negligence. And I'm adding, and again, this is, I can't go into all the detail, but in most cases, I would imagine that negligence is covered in an insurance policy if you have a liability insurance, at least up to the limit of your insurance policy. Also, there's a good chance that the insurance company will have to provide a defense, a defense for you, which means that they will provide an attorney on your behalf to defend. The next issue is, let's move on to, and I've grouped these together, gross negligence, a reckless disregard for the health and safety of others, and willful misconduct. Now, I've grouped them together because while the elements of each of them might be slightly different, which would be important to lawyers who are involved in the litigation, for non-lawyers, I think that it makes more sense just to understand certain factors and how these they differ from plain vanilla negligence. First of all, in many jurisdictions, in order to prove gross negligence, reckless disregard, or willful misconduct, in many jurisdictions, it needs to be proved by clear and convincing evidence, which is something more than by a preponderance of the evidence and something less than beyond a reasonable doubt required in criminal cases. Some insurance policies, if not many insurance policies, may not cover gross negligence, reckless disregard, or willful misconduct. So you need to consult with an insurance attorney or some insurance expert to let you know what your insurance policy covers. And I would probably rely upon an insurance attorney who would also be familiar with the laws in the state that you operate. Now, here's another issue, and this has come up very recently. It is possible that it can't be waived in the jurisdiction in which you're located. That means, and this is what I mean, and let me use an example. As many of you know, President Trump is having a rally tomorrow on the 19th of June. And they're planning on it being indoors, and my understanding will be upwards of 20,000 people at the rally. They have decided that they will not require masks, at least as of this recording, and they are going to have anyone attending sign a waiver so that the Trump organization, or anybody, not the Trump organization, but the re-election campaign, and anyone working for that cannot be held liable. So and I don't know what the law is in Oklahoma, but in some jurisdictions, it is against public policy to waive liability for gross negligence or willful misconduct or reckless disregard. So that's something else to consider. If you think that in your location, let's say you run a restaurant, and you're going to have people sign a waiver before they walk in, it may not be enforceable. I also don't think that it's good practice, because people aren't going to want to sign anything before they go to a restaurant. On the other hand, when I went to my dentist 2 weeks ago, the dentist required me to sign a waiver. So in certain circumstances, it may make more sense, but I don't see that it would make sense in a restaurant. One of the things in terms of civil liability that we were taught in law school, took torts 47 years ago, and I still remember it. It's a legal theory called res ipsa loquitur, which is a Latin term for the thing speaks for itself. Let me explain this a little bit to you, because this becomes something that I think will come into play when there are lawsuits filed and they're going to try to prove liability. Res ipsa loquitur. Here's the example that they used in law school. If there's a fox sitting outside the chicken coop and you know that some of your chickens are missing and that fox has feathers on its mouth, the burden of proof shifts. Normally, you'd have to prove that the fox, if it was just standing outside, was the one that broke into the chicken coop. But because it had feathers on its face, the court goes, it's pretty obvious that the fox was there. So there's now a rebuttable presumption that it was the fox who did it. So now let's apply this. So if you have a hotspot, let's use a restaurant as an example. If all of a sudden there's a hotspot at your restaurant, you have 10 employees. And this is where employees and the public, there's a close connection. If you have 10 employees, 8 of whom come down with the coronavirus, that doesn't mean that you've acted improperly or that the business has liability. But I think that it raises the question to begin with, if I were a plaintiff attorney, of, well, let me look at what you've been doing and why you've been doing it to prevent this spread to begin with. All right. So if all of a sudden you have a hot spot and you add one other factor, such as you didn't require people to wear masks, that might be adequate to all of a sudden put the burden on the business to prove that they're not liable. And that's what res ipsa loquitur comes into play. Now, let's look at what the reasonableness of the conduct is, because that's one of the things that we have to look at. And one of the first things that we're going to look at is whether or not there are jurisdictional guidelines or recommendations. In the state of California, there's been a mandate saying that in public and where you can't avoid being within 6 feet of other people, excuse me, you must wear a mask. In the state of Nevada, you don't have to wear a mask. It's not a mandate. So the question is, what is being required by state executive orders? What is being required for employees? For instance, OSHA has certain mandates and it has certain recommendations. What is the county or the city requiring or recommending? So you need to look at these guidelines differently from the mandates. So the guidelines are not mandatory, but let's say you have either a mandate or a guideline. And let's say you meet the mandate or you meet the guideline. Will that shield you from liability? And I think that it's fair to say probably, well, I don't think I could say probably not, but I would be concerned because I believe that the mandates and the guidelines are minimum requirements. That's the bottom line. As an attorney who advises businesses on how to avoid liability, I like to go a little bit further than the minimum guidelines, only because when you do the minimum, I don't know what a judge or jury is going to say. Let me give you another example of going beyond the minimum. I used to coach youth basketball for about 20 years. And when I coached basketball, I used to work the kids really, really hard in practice, because my belief was in practice was where all the work was. And at that point in time, there really isn't as much for me to do during a game. But we practiced so that we would win by 150 points. And I'd be thrilled if we won by 1 point. So the point is, I would grossly overshoot. I would overreact in preparation. Now, how far should I be overreacting? that becomes questions. The CDC is only having guidelines right now. If you don't even meet certain generally accepted guidelines, you're really putting yourself in harm's way. I'm pretty comfortable telling you that. Also, to the extent that your business is involved with labor and labor agreements, you have to pay attention to those also, because those may also affect what you're paying attention to. Let's move on. Let's talk about criminal liability. I don't mean to scare everybody, but if you're talking about really bad conduct, and I'll talk about this, reckless conduct, where it's really obvious that you're not doing your job. And I will explain this greater, because this could also apply to civil liability, except for the burden of proof that is required. This is certainly possible. And I've got to tell you that I've had conversations with some very ignorant people who I've been telling them, you have taken such a staunch position that you may open yourself to criminal liability. And on the news just yesterday, I've heard someone in Oklahoma talked about the Donald Trump rally as potentially criminal liability. Again, they're talking like me. It's potential. I don't see anybody doing anything unless it spreads like wildfire through the people, and they will be able to trace that. Criminal liability, there's statutory liability, where the legislature has specifically given the kind of conduct that will provide or make someone exposed to criminal liability. They specifically set forth the conduct that someone could be liable. And let me use this as an example. Driving under the influence. All right. Before a state may have set forth a specific statute, driving under the influence and causing harm to people was probably also, they were able to criminally prosecute people. When they passed certain laws, they actually took some of these grossly negligent conduct and imposed liability for merely getting into the automobile and driving under the influence, or sitting in an automobile under the influence without causing harm or injury or getting into an accident. So those are very specific laws. Let's talk about recklessness. And some of these statutes have taken these concepts of recklessness and imposed statutory liability. Recklessness involves knowingly exposing risk with wanton disregard for human life, and I would argue health, and essentially deciding you're going to run the risk. I'm going to have 10 drinks and I'm going to get into the car. And even if I don't cause an accident, I'm going to run the risk. I'm not suggesting that I'm doing it, but that's the argument. Now, knowingly exposing people to risk. What is required here is you need to have the foreseeability of consequences. Again, wearing a mask has become a big issue with me. So I go into a restaurant and here in Nevada, and people are not required to wear masks. So a restaurant doesn't require it. All right. The question is, if you don't require people to wear masks, not at their tables, it doesn't make any sense. But when they walk into the restaurant or they walk back and forth past other tables, is that knowingly exposing people to risk? That becomes a reasonable standard. My opinion is yes, but that may not be the opinion of a judge or a jury. But that's something to consider, because in my opinion, people walking around, allowing people to be in close contact. We've seen pictures. I think it was in Arkansas where they reopened bars and people were crowded in a restaurant, and they did nothing to prevent that from happening. Is that knowingly exposing people to risk? Maybe in Arkansas, they don't think so. I do. That is a difference of opinion. They will use a reasonable person standard. Now, what does that mean? I think a reasonable person standard can vary from jurisdiction to jurisdiction. So what a reasonable person standard might be in California or Oregon or the state of Washington or New York or Illinois may be different from South Dakota or North Dakota. So whatever I tell you is the reasonable, I can't even tell you what a reasonable standard is. I can only give you my opinion. Excuse me. And I don't have COVID-19. At least I don't think I do. And of course, in criminal matters, it has to be proven beyond a reasonable doubt. This is a very high bar. This is very difficult to prove. So this is, in terms of criminal liability, much more difficult to prove. But if you wanted to prove gross negligence or reckless disregard or willful misconduct, you'd still have to prove knowingly exposing risk, wanton disregard for human life, willingness to run the risk, but you wouldn't have to prove it beyond a reasonable doubt. Depending upon the state, it may be by a preponderance of the evidence or by clear and convincing evidence. And again, for those people watching, and for any of you who haven't done it, please go to CRE Radio on YouTube, subscribe to my channel, and click that little bell, which will allow you the opportunity to get my videos. Or on Facebook, on CRE Radio, you can follow me. Here are my 3 key elements to avoid liability. 1, planning. 2, training. 3, enforcement. All right. And I figure that enforcement is going to be the most difficult part of this whole process. The first question is, did the business create a plan to protect employees and the public based upon readily acceptable guidelines? All right, that's the first part. It's only part. So, and here's where I'm going to, being an attorney, I'm going to say document, document, document. This is going to be very, very important. Where did you go to come up with your policy? Did you hire someone to write it for you? Was that person an expert? Did you write it yourself? If you wrote it itself, well, let's assume for the moment that it's in writing. If you wrote it itself, what did you rely upon to come up with this plan? If you just kind of winged it just based upon what you think, well, if you run a restaurant, you may not be expert enough, or maybe you are. Knowing, if you're an experienced restaurateur, maybe you know a lot about health codes, etc., which I hadn't mentioned previously, but health codes are an important element to pay attention to. The next question is, with this COVID-19, there's so much changing and so much information that, you hear masks work, masks don't work. You can get, I've heard all kinds of things back and forth. So as new information arises, have you changed the policy to accommodate the new information? So you have to be diligent. I'm going to use that term over and over again. You have to be diligent. Are you relying upon scientific evidence or just kind of guessing or something that you read on Facebook or Twitter? I'd be a little bit concerned about relying on Facebook and Twitter. And I think it's important in terms of updating your policy. It may make a difference if you're in a region or an area or state or city that has become a hotspot that previously hadn't been when you originally wrote the policy. I mean, if you go to Arizona right now, what's going on in Arizona is different than what was going on a month ago. And maybe your policy should be a little bit different during the time of increased transmission and hospitalizations. Let's talk about the next element, which is training. All right, let me give you an example before I go any further. When I prepare a webinar, I write an outline, and then I start filling in the outline as I go along, just pouring out my thoughts. And then I go online and check my legal basis to make sure that whatever I'm saying is accurate. I then create a PowerPoint. And after I create the power, and all of this is a process, I then go on and compare the PowerPoint to my outline, and I update both. I then rehearse before I do the webinar, because I'm just using this information as a guideline for me so that it's easier to watch and read, I hope. For your purposes, if you've got a policy in place, you've got to train your employees and maybe even yourself on how to follow your policies. I can't tell you how many times I've walked into Smith's or Office Depot that the employees were either wearing their mask below their mouth or below their nose. That has another issue, but I suspect that they either didn't train their people well enough, or when we get to the enforcement issue, they're not properly enforcing their policies. There also needs to be training. What if a worker is positive? Or what about through contact tracing? Someone actually had been to your premises and had tested positive. So the question is, what are you going to do and how do you train? Are you going to, with your planning policy, just react? You know, I've got to look at this, or do you need to train your employees so that they appreciate the seriousness of the situation and they actually follow policy? And in my opinion, most people get policies, they don't even read it. They hear one or two things and then they don't do anything. So I think training is an important element to this. And finally, probably the most difficult part is enforcement. Now, we're talking about enforcement not only with your employees, but enforcement to your public. All right. Now, what if you say you require customers to wear masks, but nobody does anything to enforce it? And all of a sudden, now those customers who are coming in and they're not wearing masks, the odds have increased. I understand the latest data indicates that the odds have increased from around 3% to almost 18% in terms of spreading the disease. All right, so at that point, if you don't require your customers to wear masks, you're exposing your employees to the disease. Even if you put up plexiglass, et cetera, or perhaps plexiglass is enough to mitigate the issue. But I've seen situations where the employees, the people sitting at the cash register with the plexiglass protecting them, the other people who are out and about are not wearing masks. I've actually seen it. This is, again, a diligence issue. You have to pay attention to what the employees and what's going on in the stores. If you don't follow up, if you just say, here it is, this is what you need to do, and then you don't follow up and you don't pay attention, that is problematic in my opinion. So due diligence means that you have to go in and you have to insist that whatever the policies are, they are followed. And again, this is a document situation. When I was general counsel for Big Bear Markets, this is before cameras, well, not before any cameras, but you didn't have surveillance cameras. We had slip and fall. I had to deal with slip and fall cases all the time. Sometimes it was intentional. Sometimes it was a true accident. And we would do a number of things to try to mitigate. So for instance, where there were grapes, we would put mats down. The mats didn't seem to be enough. So we would encapsulate the grapes into bundles in plastic that allowed the grapes to stay fresh and at the same time not fall off in the floor. We also instituted, and this is more of a documentation to minimize liability, is sweep reports. And I imagine that supermarkets continue to use sweep reports. So every hour someone had to go through and sweep and then sign a sweep report that they did it. That's the documentation that's necessary. You don't need a sweep report necessarily if you have a restaurant, although that's probably required because you don't want people to slip on food. But you do need to keep some sort of documentation of what you did and how you did it and how you enforced the policies. Now, what is lack of knowledge, what the employees and public are doing in the premises are a defense? Well, I would suggest that the answer to that is no. It might be a defense if you're indicating that you don't have lack of knowledge or it's an isolated incident. How much effort was put into all of the above? All right. That's a good question. And that's one of the questions that I would ask. If I were a plaintiff's attorney prosecuting the matter, is did you just kind of put something together and then say, here, go ahead and proceed? When you talk about employee litigation matters, employees get manuals, employment manuals all the time, but nobody ever reads it. You know, what did you do to make sure that the employee read it? Maybe there's an additional duty to make sure that your plan is effective and is actually carried out. Now let's talk. Now I've talked about all the potential liability. All right. This is all the stuff that could happen. Now we're down to the practical business of lawsuits. Is there liability? This is when an attorney considers filing an action on behalf of a plaintiff, particularly something that is on a contingency basis. The attorney is going to be looking at a number of different things. The first thing is there liability? What they're going to consider what the burden of proof is. Obviously, in a civil case, what's the burden of proof? Do we really want to prove reckless conduct? So is the burden of proof by clear and convincing evidence. But you also want to determine what it's going to take to prove the case. And I think that kind of goes back to the original question that was asked, is what is it going to take to actually prove the case? How do you prove that someone or the public got COVID-19 by coming into your premises? How do you prove that they didn't get it somewhere else? How do you prove that they didn't transfer it to your employees? And it really makes a difference here. Well, I'm going to suggest, now I know a lot of the governments, state governments have been talking about contact tracing. testing and contact tracing. And I know testing has improved here in the United States, but I'm not sure to what extent. And I'm not sure how accurate the testing has been. And I know there's been discussion of contact tracing. I suspect we're going to see more and more contact tracing. And this is where we have this juncture between employee liability and public liability. If I were a plaintiff's attorney, I would look, if I'm looking at premises liability and the spread to the public, I would first look at this to see how many of the employees have become infected and over what period of time. My next step would be then to investigate what the business did to prevent that from happening. All right? That's very important. So if there's a hot spot traced to your business, then all of a sudden everything that you did in terms of planning, training, and enforcement come into play. How many employees were ill or tested positive? Let's talk about more about the practical business of lawsuits. So the attorney really has to make this decision. God bless my friend Jeff. He is laser focused on whether or not he's going to take on a case that's either going to pay or not, and how much work he has to put into it. If you suspect that there's liability, an attorney's going to consider how much effort is it going to take for me to prove the case? Not what is right or wrong, but will I be able to prove the case, and how much time and effort has to go into that? And accordingly, what are my costs going to be in order to prove the case? And in this regard, you also have to consider what the damages are. If you're talking about someone who is one person who got sick for 3 weeks, fortunately not die, but if they got just sick for about 3 weeks, what's the potential liability? What, $20,000? Maybe even less? Don't know. Are you going to spend $100,000 of your attorney time to prove and collect on a $20,000 case? That doesn't make sense. On the other hand, there are a lot of attorneys out there that work on volume. So they'll just take case after case after case, assuming that the vast majority of cases are going to settle and they don't have to do that much work. One of the key factors to consider is the collectability of the judgment. And in this regard, you're looking for a defendant with deep pockets, a major corporation whose finances are not at risk, or insurance coverage. And you want to know what the coverage is. All right. And we're talking about availability of insurance. And then I do want to mention class action lawsuits. And with my conversation with Jeff, we did talk about class action lawsuits. And from my perspective, a restaurant chain, a national restaurant chain that really not only doesn't prepare an adequate policy, but doesn't adjust its policy from location to location. So if you're in all 50 states or you're in Canada, the plan, the enforcement, the training may be different from state to state or country to country. And what I've seen, at least in the real estate factor, is that there's often an attorney in the home office who prepares one plan for the entire business wherever it's located. And if they do that and they do not pay attention to the differences in jurisdictions, and if they do not prepare adequate training, it seems to me that a class action lawsuit might be applicable. All right, so in most, and actually a class action lawsuit could be applicable even in a small location. So if you have a single restaurant and you have a large amount of employees who've become sick and a large amount of the customers have gotten sick and you were able to trace it, you may have a class action lawsuit by the multitude of employees or by the multitude of customers. A perfect example is there was a class action lawsuit. There is a class action lawsuit brought by employees of McDonald's, claiming that McDonald's did not adequately prepare them and train them for COVID-19. I don't know the details of the case. I just know that the lawsuit was filed and that was the claim. So it's real. It's real. So we talked about practical issues of proof, and that's me. I'm the presenter. So if you need to get a hold of me, you can get a hold of me at howard@hfklaw.com or Howard at CRE Radio and TV, or look me up on LinkedIn and link to me on LinkedIn. Now, I do want to add two more things, one of which may be a little cheesy. About 4 weeks ago, I decided that I was going to help landlords and tenants, and I was going to offer my services to a maximum of 25 hours per lease at a total cost of $100 per hour or $1,500 flat fee. All right. At the time, I offered it to 60, not 60 tenants, but 60 leases maximum through July 31st. So if you retained me and took advantage of that opportunity before August 1st, you could get it. So it was a maximum of 60 leases or retaining me before August 1st, whichever came first. I currently only have 16 leases available. So if you have concerns or you know somebody who doesn't know how to negotiate rent relief, you should have them get a hold of me. I will not renew it. My normal hourly rate for consulting services is $395 an hour, and for litigation, $495 an hour. So this was done, believe me, to help people out who otherwise weren't in the position to handle the rent relief negotiations on their own. So while it may sound a little cheesy, I really do believe that I'm helping people. And if you think that you might be able to help people, then you might want to do it. And finally, I'm going to add another personal note to this. If you don't really care about wearing a mask and preventing the potential spread of COVID-19 to other people around you, because that mask is not for the purpose of protecting yourself. To protect yourself, you're going to have to social distance yourself. But if you're going to be out and among other people, you really should wear a mask. But if you don't care about whether or not you're taking care of other people, after listening to this webinar, maybe you'll care about the financial repercussions of not taking adequate measures. And I think that at this point in time, when we're talking about mid to late June 2020, I don't think that there's any question that wearing a mask helps prevent the spread of the disease. It may not be the only thing, and it isn't, as someone else suggested, it's not 100% effective. Probably not. But it is a problem. And if you want to avoid liability, I think wearing a mask is one of the essential things, even if your state doesn't require it, even if your regulations and suggestions don't require it. Just telling people that they should wear masks, that you encourage or you strongly encourage the wearing of masks, knowing that most people are not going to pay attention to that. It's problematic. guys, this is about helping each other out, which doesn't mean that I can work for free. But certainly, if you got a question, I'll do whatever I can to help you out. You take care and stay healthy. This is Howard Klein signing off.